Good evening, everybody. I am so glad that we are at jury assembly training number 4, and tonight we will be learning about court process and how to actually do the court in the courtroom. This is very exciting. This is where our jurors will get to see exactly how it goes. Our court officials will kind of finally know what to do with their role, and so I am going to go ahead and get started. We will do the question and answer at the end of the training. I emailed everyone a copy of everything I'm going over. It's in your email, so you guys should have it tonight when the training is over. Again, I will shoot you guys a link to the recording. So let's start. So normally when we would go through to get to a jury, you would normally have to go and do your paperwork process. This is your 30 days, your 10 days, 777 for invoices, and then your lien. You do all of that to be able to bring something to our court. Once that process is done, then you're going to submit all of that administrative process documents to our courts. Once you've submitted that to our courts, then it would go in for a, you would get your law of the case together, all of your facts and statements and everything together. You would bring it back into our court clerk. Once it comes into our court clerk, you can then file a claim report, and that claim would put you in for a arbitration. You would get all your witness testimony, all of your stuff, submit it to the court. The accused is also made known. They would have time to get their court stuff in. They get all of their facts and information in. It's done in advance. Then you have an arbitration. So the second step usually is an arbitration. That is going to be a hearing with 3 jury members instead of 12. They would be selected from our jury pool. And you would have a judge, you would have a clerk, you would have a recorder, your bondsman, and your marshal. So all of your court officials would be there, but you would only use 3 jurors instead of all 12. Now, what you try to do in an arbitration is you try to come to a resolution. The whole goal of that is to come to a resolution with 2 or 3 witnesses, which you would have 3, which is your jury, to come to a conclusion. If you are able to come to a conclusion in that, then you would follow the procedures, which we have all of this paperwork, all of the paperwork that's mentioned here. They would follow the paperwork saying that they came to resolution. If they didn't come to resolution, then the clerk would assign a number, and it would go in for a living court. This is your 12-man court. This is our court with the jury and everything. Now, we skipped it this time. And the reason we skipped arbitration in this case, because this case is not completed. This case is one that is already going on, and because of the mischief that was going on, it had to come in through the grand jury. So our grand jury is the one that ordered this court into session that we are going to have on January 21st. So the paperwork process for this court that we're having under these circumstances is a little bit different than the paperwork process that's done for court cases that are already finished. Okay? So here's how the living court flows. You've got your 12-man jury. They have their affirmations, which all of our jury already has affirmations on file. There's the summons for the accused, which we already have that stuff that would go to the jury. You have your witness affirmations, that making sure that any witnesses that appear before the court, they have to have their affirmations in as well. And then your officials have to make sure that all of their affirmations are done as well. So when you come into court, the marshal is going to confirm all the evidence from arbitration. For this case, there won't be anything from arbitration, but he'll confirm all the evidence that has come in from this case. He'll secure the room, make sure all the Zoom connections are good with the jury to receive all records. And so what that means is the marshal, when the jury goes into deliberation, the marshal is actually going to go into that room with the jury to make sure that the screen sharing works okay, that whoever has, make sure everyone has all the evidence that is there and can access it, that everyone can access it and that can be seen on screen share in case they need to share the screen on it. So that's what the marshal will do there. Now, your justice will verify all the officials are present. He makes sure everyone's seated. Then he'll go through the oath or the affirmation for the jury. He'll give a jury affirmation for them, and he'll do a roll call affirmation with the officials as well. Now, after that, the clerk would call to order the claimant and give a list of the claimant and the defendant, who they are, the claimant and the accused. So she'll say, call to order, and she'll list the case number AR-026-2023-001. And the claimant is Joe Henry, and the accused is Jack Frost. So, and then she stops. And then when she's done, then the bondsman will then affirm the claimant. So the claimant, when you affirm the claimant, the bondsman has two questions that he asks. And I have those later down. I'm just kind of showing you on this chart. The claimant then will tell their story. So this is when the law of the case and the court of record and any witnesses that the claimant has will actually do their whole case right there. So they will get to tell their whole story, share all of their evidence, share everything. And when the claimant is finished, if there's any witnesses that have come in, then at that point, then the bondsman will affirm those witnesses as they come in. They'll come in and give their testimony. But in this case that we have at this moment, I don't know if the case coming up on the 21st, if there's any witnesses that are coming in or not. I don't think there are at this point. But so you tell your story. Then once the claimant tells her story, all of that's done, then the clerk will call to order the accused. So the clerk, so when I say call to order, they'll just say order in the court. It's like saying they're speaking. So it's when you stand up, they would just say call to order, and so the bondsman will say it, the clerk will say it, the justice will say it. Anytime that they're going to speak, that's how I call to order, and it just lets everyone in the courtroom know that you're now speaking and taking the floor. So that's, you just call to order, and that's how when you see that, just know that's how you, as an official, no matter what position you're in, when it's your turn to address the court, you will say call to order or order in the court. It just sounds better saying call to order, and then just go ahead and say what you have to say. Then so when the clerk calls to order the accused, she'll call them to order. Then the bondsman will come up and he'll affirm them and ask them two questions. Then the accused will tell their whole story of what they have. And then once they're done telling their whole story, then the this one on this paperwork says the recorder pauses the recording and lets them go for jury deliberation. But based on the this is the stuff from Utah here and from Alaska. This is all of their stuff. The only difference that we have on the stuff that we have from the old common law stuff, the jury actually gets to question because you don't have attorneys in the room. So the sovereigns are the questioners, and so the sovereigns are your jury. So in both of these, and I will probably need to change this chart to fit us, because the jury is allowed to ask questions to the claimant, to the witnesses, and to the accused. And so, and when they're done asking questions and they, as the jury, feel content in exhausting whatever questions they may have, then that's when we go. So this chart is actually a little different than ours, but in the one I'm fixing to show you, it has it listed out a lot easier. So in this second chart, here's the jury. So now the jury is in deliberation. So they call this a jury principal here. We call it a jury foreman. So the living jury, you have your jury foreman. You'll all get together, have evidence and facts. The who, what, when, where, how, and why. The jury is going to look at the who, what, when, and where, and how, but you don't look at the why. And the reason we're not supposed to look at the why is because we can't judge motive or intention or what we think they might have been thinking to do. So the who, what, when, where, how is what we're actually supposed to stick with. Established harm, if there's any, is there unlawful pressure, then we have paperwork. So when the jury is going through, when the jury has their packet, and in your packet you will have an order or a nullify order. If you get findings or if you get awards, we have paperwork for all of those type of things. So let's just say in your case that you're going to nullify an order. So if you know, let's say you nullify an order from a lower court, we have the paperwork that says this is a nullified order from the common law jury, and it'll list the case number, and then it'll list the cases in the de facto that you're nullifying. So we have that. So say you nullified an order because there was no harm, no one was hurt, and there was no loss of any items or property stolen from anybody. So it's really not a crime. So you nullify the order. So then you have a paperwork that says what your findings are. Your findings are, what did you find? Did you find that they were that they had brought damage against the claimant? If they brought damages, then you need to find what damages were they, what property did they steal, what did you, and then the awards would be, okay, can the property be returned? If the property can't be returned, then what are the damages based on the action? So there is paperwork for this as well. The jury foreman also keeps order, and the jury foreman will present to the justice. So they'll present their findings. Him or her will present their findings to the justice, and then once that's done to the justice, then it'll come through the court. And if you have a unanimous finding, that's where you do the monetary award, the findings form, the court order, all of those jury decisions, and nullify court order. That's all that paperwork. You would seal the case and seal the documents, forward to the court recorder, and secure for safekeeping. And then the orders, then you have to decide, are the orders to be sent registered mail, or are they to be carried by a sheriff to the claimant and to the accused? That needs to be decided. And then the marshal would collect any evidence and records, secure with the recorder for safekeeping. And so that's if it's unanimous. If it's a majority, so if you have a majority vote and it's not unanimous, then you would request for the clerk to reschedule an arbitration hearing again. So it would actually get bounced back into arbitration. And the reason it would get bounced back to arbitration is because obviously there's not a unanimous vote. And so if you kick it back to arbitration, then it gets the opportunity to get more evidence in. Maybe it's evidence that's missing. Maybe it's something that's missing, or you're hoping again to come to resolution at arbitration. So you can either go back to arbitration, or if it's just a majority vote and it's not unanimous, it has to go into a court continuance. And we see this in trials all the time when they go into court continuance. Say, you know, when they finally go into jury deliberations, you know, that very first day, you think, oh, well, they may come back with something quick. But if they don't get finished in that day and they run out of time, then they'll have to come back to that. The jury foreman will have to come back to the court and ask for a continuance that we haven't reached a resolution. So then the judge would come in, or the justice would come in and schedule the continuance in the court, and then adjourn court after, you know, they would schedule, the justice would say, you know, I resume court on, you know, Monday, January 22nd at 6:30 p.m., you know, and then they would all come back. So then the clerk would then reschedule for arbitration if it's an arbitration, and there's the notice. There's just the notice. You seal the arbitration. Or the clerk would reschedule for continuance. And then you seal the documents. The marshal collects the evidence and secures safekeeping for the recorder. Okay? Then the recorder stops the recording. This is from the Alaska and Utah and the assemblies. This is, and it's a pretty good little chart. But let me show you ours. And so here's kind of our chart for kind of the same thing, to be able to kind of go through a court. So your marshal, before court starts, he's going to confirm the evidence is there. He's going to make sure that all the right people are there, like there's not people here that aren't supposed to be here. In a real courtroom and not a digital one, the marshal's going to make sure that there's no guns in the courtroom, that you know, different doors and stuff are secured or locked, looking to see who's in or around. So they just want to make sure that everything. So on our courtroom, they're just going to make sure that it's secured, make sure that you don't see any other people coming in, make sure nothing gets out of hand, just that type of thing. So this, where it says process line out for courtroom to admit all arbitration information to jury, on ours, we're going to give the information to the jury. So but if it's coming up from arbitration, we need to make sure that the jury has that information. And so the marshal is just to make sure that it says in here in red, for the marshal line out the best way to do that, because you're going to be going in and out of that courtroom or the jury room to make sure they have everything that they have. So once the justice makes sure we have everything as far as evidence, make sure everything's secured, then the justice is going to verify that the recorder, the clerk, the bondsman, the notary are present, and then the living court will begin. Again, the justice is going to verify with the marshal that all participants have been identified and are cleared to be in the living court. And it's going to say verify arbitration has been conducted with those forms, but we don't have forms on this. What we have is an indictment. We have an indictment for our grand jury. So on ours, on this particular case, we're going to verify that the indictment is in with the paperwork, and it is already sealed with the court on the one we're fixing to do. So then they would press the record button for court, and the justice. This is supposed to say justice. The justice is he'll start off, and he or she will say, today is Sunday, January 21st, 2024. The time is 2 p.m. Central Standard Time. This is the Arkansas State Common Law Court. I am your State Justice, Will Harrison. And then he will immediately go into the affirmations of officers and jurors. He will say, I am going to have each one of you affirm this by saying, I affirm, after I read the affirmation. I will faithfully perform my duties as an officer of this common law court according to the principles of natural justice, due process, and the common law. I will act at all times with integrity, honesty, honor, and lawfulness. I recognize that if I fail to consistently abide by this affirmation, I can and will be removed from my office or as a juror. I make this public affirmation freely, without coercion or ulterior motive, and without any mental reservation. When I call your name, please answer, I affirm, if you agree to this affirmation. And so, Adam LaSalle will then say, I affirm. Nina Williams, she'll say, I affirm. And so he actually would say, Marshall, Adam LaSalle, he'll say, I affirm. Court recorder, Nina Williams, I affirm. Court clerk, Robin Green, I affirm. Bondsman, Daryl Penner, I affirm. Notary, Kimberly Baker, I affirm. And the jury members, you go through the list of all their names. When he calls their names, they say, I affirm. Everyone's affirmed. And now I know that our officers have already done an affirmation, and our jury members have too, but it doesn't take very long to do this, and we have to do the roll call at court anyway. We have to make sure officials are there, so it's just better to just do it. And it'll keep it in front of people's minds if they do it each time we have court. Then it keeps that in your mind of, okay, I need to pay attention to due process. I need to pay attention to common law. I need to act in integrity, honesty, honor. It reminds us to do that. And so he'll go through all of those. Once that's done, then we go straight into the recorder. That's going to be Nina. She'll say, a call to order. This is case number AR-026-2023-001, and the living name of the claimant is Cheryl Corville, and the living names of the accused is Joe Graham, Danny Thrillkill, Cara Petro, Michelle Lawrence. You just do it like that. Then right after that, then the clerk is going to say, and that's going to be Robin, call to order. For this case, the claimant is to testify first. The claimant is first to testify. And so then the bondsman, now, the bondsman is not going to say call to order, because the bondsman is going to talk directly to the claimant. And the bondsman is going to say, do you, Cheryl, promise to tell the truth? And she'll say yes. Do you agree to abide by the jury's decision? And they'll say yes. Then at that point, the claimant will tell their story of who, what, when, where, and how. The why is not supposed to be in there. And then that's where she'll also tell if there's fees, if there are any, anything that she's asking for in damages. She'll go through the whole, this is where she goes through the whole law of the case, the whole court of record, all of her evidence. It's all there. It'll be in 3 PDF forms, and she'll go through all of that. Then the clerk will then call to order for case, and the accused is the second to testify. And so if you have, for instance, 5 accused, well, then you would go through, and the clerk, once everybody's done with that, they're done with that section of telling all their stuff, then the clerk would say, call to order, accused is the third to testify, the fourth to testify. It just depends on how many you have. But so the call to order, accused is second to testify. The bondsman's going to come up. He does not say call to order here because he's asking a direct question to the accused. Do you promise to tell the truth? Do you agree to abide by the jury's decision? Then the accused will tell their story. And then once the accused is done telling their story, and all the facts have been presented and all witnesses are in, then the jury has the opportunity to question the claimant. Once the jurors will then raise their hands, and the justice will call on them one by one until all questions are answered. Once finished, the justice releases claimant from the witness stand, and then accused will be questioned as well. And then once all of your witnesses are questioned and all of the claimants and the accused are all questioned, then that is when the recorder or the Zoom host will pause the recording. Once it's paused, the jury will go to the living courtroom, and the marshal will go with the jury to the jury room. The jury will need to immediately vote on a jury foreman. The foreman and marshal exchange phone numbers in case there's a problem. The marshal makes sure that the screen share works and all evidence is able to be seen and used by the jury, and the marshal is the jury's point of contact. Once the marshal leaves the room, the jury begins deliberation. So, 3, and let me go to step 4. All right, so step 4, procedure step 4. This is when your jury is in the jury room. So, you've just broken out. The jury is now in their room. You're immediately going to elect a foreman. Your foreman is going to make sure that you have all of your orders, like if it's an order, they're going to make sure they have all that paperwork that can be hand filled out, and it can be typed up later by the clerk. But as long as it's filled out and signed, it can be typed up later. But the discussion of evidence and facts, it's the who, what, where, how, were they wronged? This is where you would establish harm. Are there violations of rights? Are there violations of law? Did they have unlawful pressure put on them? Is it a territorial or American? Who is this affecting? Is it a territorial citizen or an American state national? And then you'll get all of your information together. You guys verify that all of your jurors are in agreement. Once you guys are in a unanimous agreement, it has to be unanimous. Once you guys are in a unanimous agreement, then you can leave the room, return to the living court. If you're not unanimous and you've had a couple votes and you're still at a majority and can't come to a conclusion, that's when you might need to establish a time limit and come back. It might have to go through arbitration again. So that's where that is. So once the jurors return into the courtroom, all officials and claimant and accused are gathered back into the courtroom. The Arkansas State Common Law Court is now resumed. Hang on just a second. I got to push the... I'm noticing where I didn't put my stuff in today. Record. We got to press the record button before we can do anything else. I have to make sure we do not forget that. That's key. So when they come back in, they would press record. The justice would start. The Arkansas Common Law Court is now resumed. Has the jury reached a verdict? The jury foreman says, no, we have not. So this is where the justice can ask, well, have you not because you don't have a majority vote? This is where he can ask questions. Or you just didn't get finished today. And so let's just say that, no, they have not. They just didn't get finished. Then the justice would schedule a time for jury to convene. They would do it right then. The Arkansas Common Law Court is adjourned and will reconvene on, let's say everybody decided to do Monday, January 22nd, 6 p.m. Then you would come back and meet again for the jury to break out and go into deliberations until they come to an answer. Now, if the jury has reached a verdict, then we follow with this. Jury foreman, the justice asked, the Arkansas Common Law Court is now resumed. Has the jury reached a verdict? The jury foreman will say, yes, we have. Justice will say, please read the verdict. The jury foreman reads the verdict. At this point, the justice may have final inquiry into the verification of jury's decision, whether it's like a hung jury, or if there's more evidence that's needed, or if there was any questions. This actually was supposed to come up here. I don't know why it's right there. Hang on just a second. This is where the justice is going to ask questions. I said that, but I didn't actually know it wasn't in the right place. So when they have not reached a verdict, the justice may then ask questions of why. Are you hung, or you just didn't get through all the information? What's the problem? Or maybe you're in the middle of deliberations and y'all didn't get finished with all of the findings or award monies. You just didn't get finished. Then you would reschedule. So the judge would want to find out if, did you get all of this stuff done? Where are you at? Okay. Then they'll schedule a time to reconvene. The Arkansas Common Law Court is reconvened. If it was yes, they would read the verdict. Let me take this off of here. Then once the verdict is read, then once the reading of the verdict is done, then the Arkansas Common Law Court is now adjourned, and it would adjourn because that would be the verdict of the Common Law Court is the verdict, and that is the sentencing. And so we would go from there and stop the recording. Now, once the recording is stopped, this is where the justice would seal the order to move it back to arbitration, or the justice would use the court seal for a continuance. Make sure that the clerk has set the new date on either a form, seal the case documents, and all that get forwarded to the court recorder for record keeping. Request the court clerk to put arbitration on schedule if needed. The marshal then will collect all evidence for secure location in courthouse or recorder's room. Ask the court if it'll need a courier at a later time to deliver jury decision, or if orders need to be done registered mail or courier by sheriff, the claimant, and accused. So that's kind of how you do a court. It's real. It's not difficult. We don't talk much. Your officials, they're real specific in what they have to say and what they have to do. For instance, if anything is needed, we're not in a building, so it's going to be it should be a lot easier for us to do this. But there's your jury court procedure. And let me come back here. That is all I'm really going to go through on it for now. Next week, we will be doing a mock trial. So there's the information for it. Next week, we're going to run through it on Tuesday. So if the court officials are not here, we will use someone in their place to be a court official if they have to be one that is set. So if they are only able to watch the recording, then we'll use whoever's here to step in for any of those officials. So that is all I have on how to do court. Any questions?
I have a question.
Yes.
What happens if they don't show up for court? Do I proceed with what my testimony and stuff, and then that's the end of it, and it goes from there?
So if they don't show up for court, it's in those notices. We've told them in the notices that if they do not respond to those, that there would be consequences, that they would be tried in their individual status, and that the judgment would be a default judgment. So they're in default judgment now. What this would be with them not coming is a final judgment. And we did let them know that they've had time. So it's all in our notices, letting them know that if they don't show up, we hold court regardless, and our jury will go and meet regardless. Because the interesting thing is usually the de facto, they don't deal in facts. Like the common law court deals in facts. Everything that you're going to give in this, Cheryl, is facts, not hearsay. So all of the evidence that you're putting together in your case is going to be factual. It's something that we can prove or show. They don't let you talk about facts, really, or don't care about facts in a courtroom in the de facto. So them not showing up is just making the case better for you, especially since they've defaulted this far. But yes, we move on regardless. It'll be the same in arbitration too, guys. So when we start having the arbitrations for court cases that have already been decided, and we run through arbitration on that, if they do not show up to arbitration, it doesn't matter. The verdict stands. And so, yes, good question. Anybody else?
This is Robin. So mine will go to arbitration first.
Yes, yours will go to arbitration first. And we will need to because arbitration is, Robin, in the way that we do things on not a case that's like Cheryl's. So just wipe out Cheryl's case from your mind. That came from a grand jury. But on the cases that are coming through that are like traffic, those cases, once you've done all of your notices, which you have, all of that stuff done, you will need to do your law of the case and the court of record. And Will and I have finished the law on the case that we gave to you guys last week. We've actually gone in and added some things to it and made it fit us, put Ex parte Milligan in there. The Bill of Rights wasn't in there. Some of the Constitution wasn't in there. So we added things that we felt were pertinent, highlighted things. The key on the law of the case, making it easier to make it fit your case, is to highlight the different sections that apply to your case. So when the jury goes back to read it, either in arbitration or in a 12-man pettit jury, then it's easy for them to follow. But yes, Robin, we need to be working on your law of the case and your court of record next, because yours will go into arbitration next. But before we schedule the arbitration, I need all your evidence in my hand, because it's going to schedule fast. We don't have to go out so many days from like we did with Cheryl's with an indictment. It won't go out far. They'll have like 7 days to respond.
Oh, okay. Wow.
It's quick. It's quick because the case has already been decided, or it's left. Nothing's happened on it. So I mean, it's yours will be quick. One judge and one cop. So, yeah.
Well, it's 2 police officers, but
yeah, 2 police officers.
Yeah, I still need to go through the administration process with the police officers. So right now it'll just be the judge.
Okay, well, the judge is the one we need to get that warrant off of anyway. And so you would go in and we would have through arbitration the nullification order on it, because we know that you weren't doing anything wrong. It's a traffic violation for registration or whatever. We don't have to carry that, but it would go through that. And then now the interesting thing is because yours, Robin, will go through arbitration. When we get to arbitration, they're immediately probably going to want to ask for a 12-man jury. and kick yours into a 12-man jury, because this is where we would nullify the law. We may just want to go ahead and pull yours into a 12-man jury, or we could, either way, we could do it in 2 days, that's fine, or 2 sessions. The one session of the arbitration would decide your case, but the second session, because you had all the registrations and license and all that stuff, they just passed a law in January that or at the end of the year that says that if you don't have registration and tags and all that, you'll immediately have your car towed. Well, we need to have that law brought before our jury. And so your case, since it's bringing up that, we will actually shoot that to the jury to nullify that law. And actually it would be sending it back. It's a mandamus. I think it's a mandamus. If not, it's a regroup. I can't remember. There's 2 different ways you can send it into the Senate, the House and Senate, and it goes to them, and it would be delivered to them. I personally think it needs to be hand delivered to them by the marshal. But anyway, it would go to them, and it would be telling them that they would need to change that law. So there you go. Any other questions?
Kimberly, this is Robin again.
Yes.
I do want to have a discussion with you, but it doesn't necessarily need to be, it's about my case, but it doesn't need to be necessarily in this context. So I may call you after this is over.
Yeah, when this is over, just give me a call. Anybody else? Daryl, did you have something? I saw that you went off mute for a second right about the same time that Robin asked. Did you have a question? I don't know if you asked anything. If you did ask something just now, it didn't come through, and I was unable to hear it. It just sounded like a microphone squawking for just a second. Daryl, if you're unable to speak and you need to ask something, Daryl, if you're unable to speak and you need to ask something in the chat. All right, so I don't know if Daryl had a question or not. If he can't, and if he wants to try to type it into the chat, I'm going to give him a few minutes to do that. So yes, next week on Tuesday, we will do a mock trial and test it out. And then on the Sunday of the 21st, we'll have our first case at 2 p.m. I don't think anybody's coming at this moment. They have not responded with anything, with asking for the information for the call or to send in evidence. So I'm assuming we're all just going to be in there. But we're going to do it correctly, and we're going to do it right so that there's no question that we have done anything that's out of line or out of step. And we have made sure to do that all through this process of setting things up. We have made sure that we double check everything and make sure that we are in honor and lawfully doing. Let's Okay. Well, if your mic isn't connecting, if you want to ask a question in chat, because if you have a question, I would love to answer it. If there's anything that that you need answered. So, okay. All right. I'm really sorry your microphone's not working, Daryl. All right, guys. Well, that is all I have for tonight for the training. If you guys need anything, you can text me, call me, email me, whatever you need, and I will go ahead and stop the recording.